I'm very moved, and it's very strange, I have to say, to be here and think back to the time when I first walked into the Graduate Center offices on 42nd Street. I was a dancer, and I really missed writing. And I remember meeting Marianne Cause, Burton Pike, and Fred Nichols, may he rest in peace. And all of them said, there's no problem. And they were the first academics that I ever met who said, there's no problem. You can do both. You can have a body and you can work with your mind. So this was a tremendous thing. But more than that, Marianne Cause was also a Southerner. And for me, this was a very big deal. She had wit and grace, but she also had a combination that my mother had warned me was complete impossibility. My mother used to say, if you're serious, you just can't be charming. And Marianne was both. And so I had an idea that you didn't have to choose. So for me, both as a dancer and a Southerner, and a person who grew up with the idea that the intellectual life was really, as my mother would say, the kiss of death, this place was amazing. And it was amazing also because, especially now in this time of increasing specialization with turf wars and territory and disciplinary divides, the Graduate Center encouraged interdisciplinary work. People sometimes ask me, and it makes me feel rather old, how do you know this? I mean, like, how did you know that? Where did you read that? And the thing about the Graduate Center was that there was no problem if you wanted to do Middle High German and Old French. Fred Golden taught a class on that. We were encouraged to do whatever you were passionate about. So I owe a great deal to the place. I'm really, for that reason, glad to be here and be back. And most of all, I have to say, it sounds so exaggerated, I wasn't going to say it, but I do think that if any one place, any abode could make you who you are, the Graduate Center did that. So thank you all for whatever it's worth. Tonight I'm not going to speak about dogs. And the dog thing obviously deserves some explanation, but I can wait for questions about that. I'm going to speak, of course, about the law, which has now for about 12 years been the place, ever since I wrote about the Code Noir in Haiti, the idea of law and the rules of law having more power, actually, and more determining power to create what we think of as social norms has impressed me. So teaching close reading of case law matters a lot to understand why America is what it is and what it's become. A year ago, I spent a week reading my book, The Law is a White Dog, with inmates at Riverbend Maximum Security Prison in Nashville. We challenged each other to see things differently, to get at the force of legal language, to flesh out its fictions, and to see its categories, crosswise or otherwise. I want to begin with the words of one of these prisoners, Raheem Buford, just published on his blog, Prodigal Sons, Voices from the Inside. Lingering in the air of the poorly ventilated space is a musky odor that blends with the echoes of bare feet smacking against rows of square tiles on the smooth floor. Holding my breath for what feels like a slow-motion picture, I endure this divorce from humanity, a ritual of thingification, a manifestation that is concrete of the abstract concept of dehumanization. It never occurred to me that what was happening all this time is ritual. So this evening, I want to start with the general question: what is the terrain for human cruelty, and who gets to command its shifts in species and race? It's impossible here to produce elaborations on a brutality that comes before and after all the enlightenments that have sanctioned authority and violence. So I direct my thoughts instead to a project that points not only to the law and its effects, but also provisionally to the need for a philosophical inquiry that is also political. There is no such thing as an apolitical natural history. We have only to look at Edward Long's 1774 History of Jamaica to see how a description of flora and fauna enlivens and sustains racial prejudice. Even the institution of slavery had much to do with how the earth was imagined, its landscape, its animals, its flora. So I lean toward an interpretation of literature, history, and politics, and this is the work that I am most currently teaching in the law school, that sticks us heartily in the world of particulars and concreteness. The alternative reality of law is then a philosophical problem that has everything to do with how unlikely, or rather how the unlikely or extraordinary is always part and parcel of the commonplace, the daily. Tonight, I'd like to lay out a different landscape for judicial and social cruelty. In my previous work, I tried to account for a specific history that might explain the perpetuation of legal stigma, whether in the Code Noir in Saint-Domingue, on the eve of the Haitian Revolution, in the rules, regulations, and experience of slavery in the American South, or the fact of civil death after emancipation in New York and beyond, I extended the practice of ritual to the exercise of law. I recognized legal rituals as a form of religion from which law could not be divorced. Rituals of law, I argued, had their ground and impetus in a very colonial understanding not only of crime and punishment, but of body and mind. That work might be encapsulated as follows: a quest to understand how codes of law reconfigured the logic of punishment as the language of sorcerers, and a philosophy of personhood. In my more recent writing, I offer another kind of creaturely experience that upsets the reliable and the reasonable and the moral order of things. I don't mean here to call to mind any concept of relativism, but rather to cast doubt on the robustness and transportability of the ontological partitions that we so easily assume. This is a very personal bias, since I've long tried to invoke, even if tentatively, the seepage between entities assumed to be distinct, whether dead or living, inanimate or animate, commonplace or extraordinary. Such a suspension matters to me both literally and figuratively, as a matter of politics and of aesthetics. The necessity of working in the interstices has been with me for quite some time now, ever since I first read Mallarmé, who tackled the centre du suspense vibratoire in pursuit of pure poetry. Some 80 years after him, Frantz Fanon, in calling for a people's revolution, summoned la zone d'instabilité occulte. From inside this space between poetry and politics, I appeal to a novel textual environment. I'm an old-fashioned close reader. I want to reshuffle the terms of how we come to know what we cannot know. I consider some of the cruelly deleterious ways in which dogs and humans, for example, are brought before the law, at once made and unmade as subjects of punitive regulation. What I ask in extending the legal standard of unnecessary suffering, would necessary suffering look like? Or I try to interpret a phrase like, quote, the minimal civilized measure of life's necessities. These are legal formulae that have been repeated since slave law, all the way to the contemporary prison. How are we to explain, in both granular and theoretical registers, the generally invisible nexus of animality, human marginalization, and juridical authority? And again, this is not just a philosophical inquiry. I want to contribute to the understanding of how, where, and why human beings often quite arbitrarily devise, formulate, and apply lines separating the human and animal, or the human and non-human, or more interestingly, I think, deliberately blur those lines. And here, of course, I'm thinking of the old dichotomy between primitive, barbaric, and civilized savage, animality and humanity. In a general sense, and overriding this entire talk, is a concern with how disregard works in our society. To recognize the exclusion of persons that are deemed noxious to the community of well-meaning citizens. To be made superfluous is to be outside the pale of human empathy, and I want to argue that the law frames the waste products of society in peculiarly salient ways. Once violence is authorized, it can never be impermissible or legal, or illegal. When behavior is judged along a continuum, from ideal, prudent, normal, to sullied, delinquent, reckless, general legal standards become the foundation for the conditions of civil life, but also by the same token for the ostracism of the poor, the unfit, the racially suspect. These are two sides of the same coin. So the choices I have made for this talk bear a relation not only to the brute violence of our times, but also to my trepidation in confronting so capacious and persistent a topic as law language, the language of law. A verbal environment that, as I said, is manifestly a literary terrain. In my desire to find ways both to describe the current state of affairs and to change it, I turn to that space between the legal and the literary. I recognize that the pernicious effects of that anodyne but strategic label of the discipline law and literature can best be described as the depoliticization of what lies in both fields. So in extending the treatment of persons and property to both legal and literary texts, I'm not partial to our usual understanding of that conjunction, law and literature. I don't take one or the other as a standard against which we can work analogy or comparison. It seems to me that that copulative exercise too neatly leaves law and literature each intact in their separate corners of thought. That penchant for analogy eschews, or rather assuages, the collision and conflict so necessary to their historical specificity and political reach. If we were to unsettle disciplinary boundaries, we might get at the visceral punch of legal language. In the process, we might also recognize how the literary text presents ambiguities that case law will not put forward. So I invoke the oscillation between these categories that bind. In other words, the world I summon here is that standing at the interstices that dismantles the privileged dichotomies of law and life in the Americas. Now, Herman Melville hovers throughout my thoughts today. He understood, perhaps better than any other writer in the so-called American Renaissance, how the forms of speech and heights of artifice, not to mention legal authority, went hand in hand with a history of extermination. Not only did Melville find himself in law, he created identities most recognizable in law. You don't have to look hard in Melville to find the skeletons in the closet. In Moby Dick, for example, Ishmael relates how the bones of one of the earliest species of whales were found in Alabama. But by far the most wonderful of all cetacean relics was the almost complete vast skeleton of an extinct monster found in the year 1842 on the plantation of Judge Krieg in Alabama. The awe-stricken, credulous slaves in the vicinity took it for one of the fallen angels. A very ignored passage in Moby Dick. Coming out of the upturned earth, we find a remnant of legal history, something that transpired not only in the South, the Alabama, that is also the birthplace of Pip, but also in the heavens. Natural history here is entangled with the fall from paradise, and the law, in the person of Judge Krieg, lives on through the presence of slaves, just as the perils of extinction collapse in this fantastic surmise. So the question is, can we strike, following Melville, can we strike through the mask? Are we prepared to readjust ourselves to a conception of human life that turns our own reality upside down? With us, it is the real world that seems the immediate thing, and the supernatural world, for example, something above and beyond. But once in the precincts of law, the immediate thing is the supernatural. And then, of course, the term supernatural would be an inappropriate term. It would be better to say all too natural, or natural to the nth degree. And by the same token, it is as though what we call the real world, where injury is obvious and its meaning clear, is no more than a symbolization of events in the world of legal ritual, where what is most bizarre, most incorporeal, most demonic is recast as reasonable. At issue here, then, is not whether ghosts are gods or angels are real, but whether or not in the legal world an outre or fictitious situation is put forth as natural or uncontroversial. A relentless acceptance of unreality is the most necessary part of legal history and crucial to its mythology. Because what we turned into ghosts originated in the legal language of property and persons. This logic of domination was never outside of civil society. Legal thought, especially when enthralled to the necessities of slavery, relied on a set of fictions in order to sustain the concepts of property that could think and of humans that were chattel. This fictive domain, whether from a practical or theoretical perspective, is grounded in the habits and usages of daily life. The raw materials of legal authority, its codes, fictions, and rhetoric are preconditions for the rationalization of casual cruelty and commonplace harm. I'm hitting hard on this idea of the grounding of law in our habits and usages, because if you've ever talked to some lawyers, the idea is that it's a guild and that it is very separate from what we do every day, what we think of as commonplace, right? So how do we then apprehend the unreality of legal rules? This is another alternative world where law's symbolic labor unleashes fictions that articulate the rationality of racism. Naturalized that rationality by none other than Chief Justice Taney in Dred Scott as a, quote, perpetual and impossible barrier. Up against the law, the supernatural turns into the rational, and the world of nuance and proliferating possibilities disassembles into the psychopathology that Fanon described in Black Skin, White Masks. The black soul, he wrote, is a white man's artifact. Tocqueville recognized that nothing can be more fictitious than a purely legal inferiority. And yet democracy in America reads like a founding text for an impossible equality between future black freedmen and a future, though ever phantasmal, or more precisely, ineffective multiracial citizenship. He understands how deeply an imaginary inequality remains, quote, implanted in the manners of the people. Considering how despotism operates in a society of equals, Tocqueville wrote with some vehemence, "The government of the Union depends almost entirely upon legal fictions. The Union is an ideal nation which exists, so to speak, only in the mind, and whose limits and extent can only be discerned by the United States, by the understanding. It is that hierarchy of mind and the rituals of separation it generates that concerns me. The color line is always with us and becomes more pronounced whenever modulated by another expression that is just as supple, the projection or promise of a society that is, quote, colorblind. The word color is fictitious, what is not always observable. not fact, but a presumption of status. In the United States, it took a universally applicable concept of blackness to underpin both a sense of white superiority and the privileges that were supposed to stem from it. So in some sense, the contrary intensities or fissures of color or blindness to color are mutually adaptable. The potent archaism of law can always be appropriated so as to conventionalize these very mundane but annihilating inequalities. How are ideas such as progress or freedom, sustained in an era of increased surveillance and militarization against Black communities and other communities in the United States? Speaking broadly, I would say, echoing Frederick Maitland, that it is in legal documents and legal forms that the social and economic arrangements of remote times are best made visible and applicable to us. The Black codes, penal sanctions, and other forms of unfreedom, the juridical no man's land of immigration and deportation and wide-ranging administrative enforcement form the skeleton of our body politic. But we can't be too scornful of bones, even if they're dry bones. We must know their anatomy, for it is in legal structures, are in the juridical elements held in our mind and repeated over time as precedent that become the definitions that matter. Recalling Agamben's opening gambit with Foucault in the beginning of Homo Sacer, I ask, can we construct an analytic of power that would not take law as its model and code? I am perhaps too much attached to the law, attracted to a power that is most effective when least reasonable, most compelling when it flies in the face of the obvious. In the range of comparative disabilities, it could be argued that legal constructions should not be given such free play or emphasis. Can a statute with the purpose of punishment be changed from penal law if it furthers some other legitimate purpose besides punishment? What if something that sounds like penal law, once announced to be a congressional exercise of the war power, becomes non-penal, as if a new label has just been pasted on it? Blood sticks to new rules. Think assassination by drone of targeted enemies or suspects or non-suspects who just happen to be beside them, what might be termed non-execution of non-convicts in a non-war, in an out-of-the-way foreign country, are not so out of the way. A seemingly vague phrase gains concrete significance through its history of application. Changing circumstances, once immobilized as precepts, become the lifeblood for the deathlessness of legal inquiry. So though incomplete as descriptions of practice, judicial opinions are complete wholes as structures of thought. What Robert Cover called the task of construing broad constitutional language summons a history so deeply rooted in our memory that while certain facts are repressed, the emblems of power and privilege never pass away. In 1819, when Missouri requested admission to the Union as a slave state, Judge Joseph Story publicly declared for the complete eradication of slavery from the territories. It was one of his only public stands on a political issue. Riding circuit for the U.S. Supreme Court, he wrote to James Kent, who was still sitting in the New York Court of Chancery and would soon write his magisterial commentaries on American law. Kent knew that an end to slavery, what he called that great moral pestilence, depended on whether he could awaken the ardor of the bar. He found that promise of transcendent justice and passion in principles of equity, not in the rules of common law. For Kent, as for Story, and for many 19th century legal commentators, law had to be given flesh and blood. Not only because they both disapproved of legal slavery, but because in 19th century America, the law mattered, perhaps in ways now unthinkable, to shape matters of the heart, to give or annihilate a sense of identity, to transform individuals alternately into legal subjects and legal objects, and most of all, to treat property as the origin of rights and the rudiments of personhood. But however we interpret this awesome equivocality, To understand the law at work is to put the legal in league with the kind of ethnographic critique that will lead us to understand how taxonomies or fictions, whether of blood or color, count more than any visible or obvious facts. So I give legal language an attentiveness nearly ethnographic in its intensity. There is no place where such legal ethnography is so fiercely worked out as in Melville's Bartleby the Scrivener. As you all know, Kent's character in service of the ever-elusive spirit of equity haunts the offices of Wall Street in this story that was set after the court's abolition of Chancery in 1847. In a time of unrelenting taxonomies, when persons became things, either perishables in the market or fixtures on land, and where felons died in law but lived in fact, Bartleby stands literally at the limit screen or chancel of these categories, destabilizing the definitions so crucial not only to property and slaves, but to the regulatory beneficence of civil society. Or to put it another way, the figure of Bartleby is a perfect instance of what it might mean to give a body to a legal fiction. My greatest concern, again, is the spectacle of law, and in this instance, the spectacle of law moving from a structure of norms and rights to the unequivocal logic of incapacitation, historically situated and rhetorically persuasive. Statute and case law were as important as social practice, I'm arguing, or spiritual belief, not only in effecting strategies of exclusion, but in demanding a unique definition of persons. Those civilly dead entities, though possessing natural life, have lost civil rights. And again, the legal paradoxes are Gothic turns between tangible and intangible, or life and death, became necessary to the idiom of disability and racism that is so much a part of the American social order. That disabling and its long shelf life sustained legacies of slavery, and it sustains them now in the form of state violence and criminalization. There are correlations to be made in these varying narrations, the theories and concepts of legal authority with unlimited resources at its disposal, of affirming and negating, acknowledging and ignoring, giving and taking away. The undoing of personhood has a sordid history in the United States, where the creating slaves as persons in law, criminals as dead in law, are that unique and perpetual recreation of the rightless entity, the person who has, quote, lost the right to have rights, as Chief Justice Warren put it in Trop versus Dulles in 1958. I want to turn for a moment to a speech that has haunted me for a long time. It's "The South Knows Us." It's Frederick Douglass's great speech of 1879, written before the civil rights cases of 1883. Douglass said that he felt secure that the supreme law of the land, the Constitution of the United States, would not be, and I'm quoting, changed or affected by any conjunction of circumstances likely to occur in the immediate or remote future. He trusted in the citizenship granted in the 14th Amendment. But race hatred and violence changed and affected the law of the land. This was fully realized in the Supreme Court decision that declared the 1875 Civil Rights Act unconstitutional. The decision in the civil rights cases generally returned the greatest share of power from the United States to the individual states, but most important, it struck down the provision of the Federal Civil Rights Act that criminalized racial discrimination in certain quasi-public venues. In his dissent, Justice Harlan recognized that the 13th and 14th Amendments, as well as the Civil Rights Act, were enacted not only to abolish slavery, but also to remove what he called the race line. That was the substance, he wrote, and spirit of the recent amendments now sacrificed, as he put it, by a subtle and ingenious verbal criticism. During Douglass's final years, in the last chapters of his often wrenching Life and Times, where he also told the story of his vile treatment in Haiti as ambassador, the vile treatment was not by Haitians, it was by the New York Times, he composed his lament for what he called this national deterioration. In his account of the purpose of the majority decision, he analyzed how a basic fear of proximity, a word that matters, took hold once equality was recognized. And I'm reading his words. When a colored man is in the same room or in the same carriage with white people as a servant, there is no talk of social equality. But if he is there as a man and a gentleman, it is an offense. What makes the difference? It is not color, for his color is unchanged. The whole essence of the thing is in its purpose to degrade and stamp out the liberties of the race. It is the old spirit of slavery and nothing else. To say that because a man rides in the same car with another, he is therefore socially equal is one of the wildest absurdities. Douglass recognized how civil realities created the meaning of the word social, or to put it another way, how statute and case law became crucial to this assumed split, between private and state racisms. In other words, between civil and social equality. So law for Douglass not only created the means of enforcing status, it also assailed black lives. A little over a year ago, in Sentence to a Slow Death, editors at the New York Times reported that judges, bound by mandatory sentencing laws, are sentencing to life imprisonment without possibility of parole people, most of all African Americans, who have done nothing more than selling $10 worth of marijuana, siphoning gas from a truck, or simply possessing a crack pipe. How numerous are the forms of death in life meted out to those marked for exclusion. Life Without Parole, LWOP, the novel and absurdly expensive substitute for state-sponsored execution, often in the mind-killing isolation units of the Supermax, is for many a punishment worse than death. But though apparently the New York Times found shocking this attack on those guilty of rather small crimes, the extreme and anomalous practices of punishment in the United States, as we've heard, should come as no surprise. Civil death, it matters a great deal to me. People keep ignoring it because everybody likes, we always are thinking of Patterson's social death, and the idea of the social is much more attractive perhaps than the civil. But civil death, we have to remember, it was abolished in England in the early 17th century. It crossed the waters and lived on here, even though our Constitution says that there is no such thing as attainder. Now, the history of civil death is crucial to remember. It was first in the Middle Ages attached to the blood of a criminal capitally condemned. It soon followed upon a sentence of life imprisonment. But this was a consequence rare at common law. It was only in the United States that civil death became equivalent in some states to being imprisoned for life. So to be dead in law in this country meant to be deprived of the right to vote, to sit as a juror or hold office, even to marry or leave your property to your children. It meant that you were forever distinguished from other civilly alive people. In the words of one 19th century postbellum Virginia judge, the prisoner was a slave of the state. So the anachronism of civil death came into prominence, it's important to remember, in this country only with the abolition of slavery. But we're still not out of the fog and fiction of this medieval jurisprudence. The disenfranchisement of offenders and ex-offenders forever barred from voting is estimated to affect nearly 6 million people. 1.5 centuries after the end of slavery, African Americans are 14% of the population of this country, yet they constitute 38% of those deprived of the right to vote. The future is dire. Without legal and constitutional provisions at the state level 3 in 10 of the next generation of black men will be disenfranchised at some point in their lifetime. So this talk is going to end with a reflection on the continued criminalization of African Americans in this country, which I believe drives our nation legally, politically, and socially. That a city has elected a black mayor, the country a black president, changes nothing for many of our fellow citizens who face casual cruelty and enduring harm simply because they are black. And now, after all the recent and unpunished deaths of unarmed citizens, Mike Brown, John Crawford, Eric Garner, Oscar Grant, Tanisha Anderson, Akai Gurley, Tamir Rice, and others, many others, the hyper-legal disregard of these lives expresses yet again the normalcy of law's force. How do we understand the rule and the role of law in a country with such a long history of legal stigma and obligatory degradation? What happened in Ferguson and Staten Island, what happens with regularity all over this country, of course, has this history. When slaves were emancipated, we criminalized blackness through black codes and Jim Crow. When those laws were overwritten, we criminalized blackness through the disproportionate enforcement of drug laws. Now our prisons are filled with African Americans who bear witness to a legal system that projects not their crime, but rather a phantasm of criminality that is almost always black. Now, I am not going to discuss in detail the similarities between slave law and our current law, but let me say that the sites, again, of this disfiguration are installed, and this is my argument, always in the scaffoldings of the quotidian. And much like ritual, they depend for their power on the turn to repeated words. There is a way in law, and of course this was probably why my father told me, you could never be a lawyer, and you shouldn't be. You must be rational for that. And the emphasis on rational agency is very much a part of legal discourse. But let us reflect on how strange and how irrational that moment of reason is. What many political theorists today refuse to apprehend is not only the entanglement of rational agency with the magical, but most of all the fact that the fusion of the two does not always suggest a celebration of the irrational, and irrational that is far from the values of enlightened society. I want us tonight to think about how we might reorient how we think politically. The understanding of stigmatized property, for example, calls up what remains much more profoundly mysterious and undetermined. If fictions of law are spectacles of sacrifice, demand that one is disposable, I want to say that it's somewhat worse than that even. It's that one no longer has the capacity to be dispossessed. So perhaps our own alternative to what I'm calling a positivist anti-colonialism depends on our retrieval of remnants as a new context for the political. I want to put a wrinkle in progressive business as usual. We all recognize now that the carceral system extends beyond the logic of punishment. It is a key instrument of social control, but it's also become the central public institution in the United States. And again, the issue is not crime. As you all know, mechanisms of discrimination do mark, in my opinion, the most concerted effort since Reconstruction to create a class of citizens subordinate to and separate from those outside the prison walls. But ever larger categories of our population can be tarred with the same brush. Now, there is one particular problem about the hypothetical. As you recognize, a great deal of what I've been talking about requires a certain move into the as-if. If you think of, many people have said, oh, you're obsessed with zombies, you know, all your work on Haiti. But this is not about that living dead. This is something else. This is as if someone returned in the shape of a thing that looked like a human, but deprived of everything that makes social personhood possible. And that deprivation takes place only at the moment that their life, their resistance, is most visible and most present. That is the violence of legal language. Forfeiture, as many of you know, operates now like something of a real infection in the communities of the poor and powerless, but it remains part and parcel of a long-standing projection of the acceptable or unacceptable citizen. Claims of humanitarian enlightenment notwithstanding, the police power that always accompanies legislative intent continues to resurface. No criminal conviction of the owner is required for the state seizure of property, and the idea of social rationalism and claims of decency are part and parcel of what continues to prosecute the superfluous. Tonight, what I've been trying to do is not just put us in the in-between, in the difficult interstitial and hypothetical, but rather to recuperate from the tomb of neglect the terms of abuse, to give a history to contemporary tags for the unfit or expendable. That stands before me as a goal in the university and in my life. Phantasms of criminality, as we know, drive our elected officials, our police, and our state. And I want us to consider the unreal rationality of racism that always depends for its force and its ongoing life on the force of the superfluous, what one prisoner at Pelican Bay called the castaway. One thing that's also important to recognize about the law is that prisoners really know it. They know how difficult it is to get judges to apply the Eighth Amendment prohibition of cruel and unusual punishment, for example, to psychic harm. They also know how terms like human dignity, intrinsic worth, or psychic violence are no longer recognized by the Supreme Court, at least not since the 80s. What Elsa Gavaya, and if you haven't read this, it is still unsurpassed. It is her small book, The West Indian Slave Laws of the 18th Century. She recognized as the necessary legal accompaniment to enslavement what she called the superstructure, the police laws, the unrestricted power to inflict harm. That power alone could keep slaves, as she wrote, in their fixed status as the legal property of their owners. Once you've got the superstructure, the police power in all of its manifestations, what I knew as a child simply as the laws, then you're covered. The lid's shut tight. The question is, what lies beneath that cap? Again, I return to Melville. In writing through his rage, he let dirt seep through the cracks of the literary, or as in the case of Israel Potter, through the pages of history. It is in his prose that the drama occurs. Describing the ship that will become what we know as the Bonhomme Richard, Melville prompts our double vision through a description at once bumbling and razor sharp. As for the ships that, commanded by Paul in person, will be a good example of the fleet. She was an old Indiaman, clumsy and crank, smelling strongly of the savor of tea, cloves, and arrack, the cargoes of former voyages. She was originally a single-decked ship, that is, carried her armament on one gun deck, but cutting ports below, in her after part, Paul rammed out there 6 old 18-pounders, whose rusty muzzles peered just above the watermark like a parcel of dirty mulattoes from a cellarway. It is in the simile, a seeming pocket of something extraneous, always unnoticed, that the meaning for Melville lies. It's here that Melville keeps alive his secret history, intimating a region of, let's say, indiscernibility between the ship of John Paul Jones and the hold of a slaver, or more exactly, the barrels of guns and the muzzles of faces, Melville entangles any myth of heroism with the wastes of empire. The products of trade in tea, cloves, and arrack intermingle with the after effects of trade in humans. So using the frame of conventional history, Melville eats it out from within. That is what peers up from beneath the realities of trade, the catalogue of cargo. Beneath such unseemly traffic, there always lies, hidden, waiting to be noticed, peering out from below, the physiognomy of misalliance, the fact of mixture. So in closing, I want us to begin to rethink what we think of as natural. And I also want to think again about the future of what we call political theory, who makes it and who gets to claim it. So instead of formally turning to what we call political theory, I want instead to invoke a kind of uncertain reservoir on which all creatures might draw, but from which most humans have learned to cut themselves off completely. I'm reminded here of Hannah Arendt's attempt to save political action and political understandings of action from humanitarianism. And that is the argument that has led me to the recent work on the exterminating rituals of humane society, who extinguish certain breeds under cover of salvation. But I want to think about the management and control of humans in a space that is always deeply, deeply, deeply not just political, but rather something that we imbibe as we breathe air. And it is the fact of how those who are banishment are the management of what we think of as the refuse of society, how those hidden places actually enter into us, not in the form of, let's say, a possession, but they transform piece by piece, breath by breath, who we are. And that is the question. What is the language we need today? Do words such as political theory apply to places inhabited by different sorts of subjects or persons? Key to what I've been describing here is that I have always thought that morality is different from ethics. Moral judgment takes its cue from a communal surround of privilege. It depends, to my mind, for its power, on the people who ordain right and wrong, or define what we mean by a word like civility, as well as on public acquiescence. For me, ethics takes on a meaning far less abstract. It has to do with locale, the proximity of one creature to the next, or how an individual relates to what is not familiar. To be ethical in this sense is to locate oneself in relation to a world that is adamantly not one's own. Whereas morality is an austere experience of non-relation, ethics demands the discomfort of complete relatedness. Forgotten the people in the expendable world in the corners of disregard. The question, then, is how might we think of legal history as not just a record of suffering, but also as a mode of deliverance? How it might help us to puzzle out law's alternative reality, and once come to life without any safe or customary theoretical framing, such knowledge demands nothing less than the perturbation of our confidence in what we think we know and how we come to judge. So I hope that our conversation then tonight will be proof of this abiding collective relationing, and I hope also unsettling terrain, because only then can we reconstitute what it means and why it matters to live the scholarly life. Thank you.